And we are going live.
Good afternoon, ladies and gentlemen. Welcome to another exciting installment of the Housing and Real Property Subcommittee. Today, we're going to have...
Going live.
Good afternoon, ladies and gentlemen. Uh-oh. What's happening, MJ? We got feedback.
I just paused it. It was the YouTube link.
YouTube, yeah.
Yes, so it's been paused.
Thank you. Okay, so last week, we discussed HB 693. This is the Renters' Rights Bill as presented to us from the governor's office. And with that came several suggestions for amendments. And we're going to go through the amendments for HB 693. And we have with us representatives from the governor's office as well to assist us with any explanation or expansion of the amendments to HB 693 as we go through them. And like I said, we went through the bill last week, so everyone is familiar with it by now, I'm sure. So the way I'd like to start is, Ben, if you could go through the amendments and then place them on the screen as you go through them, I'd appreciate it, Ben.
Okay, thank you, Mr. Chair. And yeah, that brings us, I'll pull up the screen now. The first amendment was one that I believe Delegate Naraki brought up, which was about clarifying the application of the extreme weather conditions would only apply to the property affected, as opposed to like the state having a winter storm in one part of the state, but not the other. The amendment's still being finalized, but the amendment is going to specify that it's going to be residential property affected by the one of the weather conditions listed here. That was pretty straightforward, but that was one of the amendments that is in the process of finalization now and to be considered by you, Mr. Chair.
Okay, great. Delegate Naraki, this was your suggestion, so take a look at it.
Yeah, yes, sir. I
give me your thoughts.
Yes, sir. I appreciate the inclusion of that, Mr. Chair. I think that's important to make sure that we're not talking about a hurricane in Ocean City, and someone in Garrett County, being affected by that necessarily. So thank you, sir, for that inclusion there.
I appreciate it as well. I think what I'd like to do is, as we go through these amendments, ladies and gentlemen, let's approve them one by one so that we don't have to come back to the very beginning of this again. Let me get a motion on amendment number 1, please.
Move favorable. Moved. Second.
Second. Okay. The motion has been moved and there's a second on the First Amendment. Any discussion, additional discussion on this amendment? Delegate Lehman.
Thank you. So could someone clarify the extreme weather language? Is it literally only relevant to the exact address of where of the property in question, or how is it defined?
Well, what we attempted to do is to try to narrow the focus so that if we have a hurricane in Ocean City, we're not having any delay in Charles County. Ben, can you expand upon that if you don't mind?
That's right. No, that's correct, Mr. Chair. And it's
could you state that again, Ben? That it's exactly. I'm not thinking about a weather warning that's on the Eastern Shore versus Central or Western Maryland. I'm thinking, weather warnings are often for a lot broader, wider areas in the area, than one specific part of one county. So how exactly is it worded?
You want to pull that up, Ben?
Yeah, the amendment, Mr. Chair, is still being
Yes.
finalized, but the language is going to read that the administrative judge of any district shall stay the execution of a warrant of restitution that is an affected residential property from day to day in the event of, and then it'll list the extreme weather conditions. So I think this is actually already the case that like they are able to navigate this in the courts, but this helps provide more clarification and hopefully resolves ambiguity.
Yeah, I can't tell from that how narrowly it's written. I'm going to oppose the amendment.
Okay. Any additional discussion on the amendment?
Well, Mr. Chair, if I may.
So go ahead. Delegate,
Um,
you have the floor.
Thank you, Mr. Chair. Delegate Lehman, I don't think we've even seen the amendment yet. So maybe when we see the language, it might offer some clarity, because I don't think that the actual wording is in there yet. But my intent with that suggestion was not to stop people from being able to, to do what they need to do in extreme weather situations. But I do think that if you have a snowstorm in Garrett County, a blizzard out there, that doesn't impact Talbot County, for instance, I don't think that we should be treating those two counties in the same way. And that's really what I was trying to get at with that language there that Mr. Chair has asked for, and hopefully will be included here.
Okay.
Yeah, I understand your point, but you're presenting a scenario that's really black and white. I'm suggesting there could be a lot of scenarios that are not so clear. Especially when you consider that storm systems, move pretty quickly. I'm thinking not so much of snowstorms, but of things like derechos and hurricanes and tornadoes. Tornadoes in particular, 1 minute a warning can be for one county, and a few minutes later it can be spread to multiple counties. So I would, I thought there was actual amendment language ready, and I would be concerned about, trying to make it so narrow that it couldn't take into account, for example, somebody that's on their way to their property, but maybe in a neighboring jurisdiction, and it's not safe to continue traveling because, where they're coming from, one county over, is under some kind of weather warning. I just think it's, weather is just too iffy. I get your really sort of stark example of an extreme weather front on one side of the state versus another, but that's not always going to be the case. That's all I'm saying.
Sure.
And Mr. Chair, I have it. I added it into the bill if people want to take a look, because it is very.
Please.
Okay,
Exactly.
yeah. So this is the added language affecting the residential property, but that may not resolve the concern.
So that's the language. That's what we're trying to get to, and I'm not quite sure how to, and I don't think any of us would have a better idea on how to broaden it or narrow it to address the issue. So at this point, what I'm going to do then, if you ladies and gentlemen don't mind, I'm just going to move forward with it, because we have it there in front of us, which was attempting to address an issue. We have a motion and a second on that amendment. Any additional discussion on that amendment? Seeing none, all in favor of that amendment signify by saying aye.
Aye.
And any opposition?
No.
Okay. So that's thank you very much. I appreciate your concern there, Delegate Lehman. I really do. Ben, let's go to the next amendment, if you don't mind, sir.
Okay, thank you, Mr. Chair. 1 second. Okay, so the next amendment, right now, there's the allocation of the fees. Here we have, this is the current bill. It's with 50 for a surcharge assessed under item 1 for the filing fees costs. That's at the start of the bill that I think a lot of people are familiar with from our discussion last week. The current breakdown is 50% into the statewide rental assistance voucher program. 50% to Legal Services Corporation Fund. And then the amendment is altering that to be 45% for statewide rental assistance, Legal Services Corporation, and then 10% into the rental assistance for community schools program. And then that we discussed this last week a little bit, but as a reminder, this program provides rental assistance to eligible student households at community schools. And the amendment would only is contingent on the passage of the bill this session. So,
And obviously, ladies and gentlemen, what we're attempting to do here is to assist as many people as we can with the problems that we're having relevant to the housing scenarios we have in the state. And that's where that the percentage just stayed the same. We just reduced the rental assistance voucher, we reduced the legal services corporation, and added assistance for the community schools family funds to include that. Any discussion on this particular amendment? Delegate Naraki.
Thank you, Mr. Chair. Sorry, I'm not on my usual computer, so I'm just trying to make sure I'm working things properly here. I do have a question with this part of this amendment, this part of the bill. I'm just curious, why are we paying attorneys here when we could just basically be helping folks out with their rent? I'm just trying to understand, if the goal is to not have people out on the street, I don't understand what we're doing here with this.
Sure, and I understand there's a philosophical difference in policy, and I truly understand it, Delegate Naraki, I truly do. And I don't think that quite respectfully, I don't think that our discussion in the percentages of these programs are going to circumvent that particular concern relevant to the policy that you'd like to adhere to versus what is being discussed in the bill, to be honest with you, Delegate Naraki. And we both have great respect for each other.
Sure, no, absolutely, Mr. Chair. And I'm just, look, I know that the goal is to keep people housed. And to me, it would seem that to keep people housed by paying, getting their rent caught up might be a better way to keep someone housed than by paying attorneys. But I'll leave it at that, Mr. Chair, because I do have a great deal of respect for you and your work. So
I do appreciate it.
Mr. Chair,
Mr. Fallon is on the line. And Mr. Fallon, if you'd like to add some commentary into this, we would certainly
I can also help with that.
So
too,
go ahead, Ben. Go ahead, Ben.
Okay, thanks. So, and just to be clear, the amendment is, it may look like it's the whole bill, but the amendment is, the current bill is the breakdown of 50% and 50% for
Right.
those two. The amendment is it's actually adding money, which is for rental and utility payments for eligible households. So.
Mr. Chair, did you want me to respond?
Sure. Go ahead.
I'll be very, very brief. I will just quickly note the eviction filing fee currently is $15. $8 of that goes to the Maryland Legal Services Corporation, as is the case, as I understand it, for all filing fees, they break down. So this is a broader policy decision by having the Maryland Legal Services Corporation that provides legal service in these cases. That's a standard practice for about half of the fee for all filings to go there.
Thank you, Mr. Fallon. Delegate Boyce.
I'm sorry, this is unrelated. Is the copy we just received the copy with all of the amendments that was sent at 2:35?
Ben, I think so. I think it was, wasn't it, Ben?
I'm not sure I didn't receive email to my knowledge at that
Oh.
time, but
So I mean, each of them have
we're gonna go
different
through them. Yeah.
times on them. So the one I have has an amended copy. It says 3/11/24 at 2:35.
Let me double check. No, that one, I'm looking at that one too, Delegate Boyce.
Okay.
And that one does
Sorry.
not have what's on the screen here.
Okay, thank you.
I apologize. I apologize. All right, so ladies and gentlemen, we have in front of us another amendment, and I'd like to get a motion favorable of amendment number 2.
Move favorable.
Is there a second?
Second.
Thank you very much. Any additional discussion on this second amendment that we just discussed? Hearing none, all in favor of amendment number 2 signify by saying aye.
Aye.
Any opposition? Thank you very much. Amendment passes as well. Let us now go, Ben, to the third amendment.
One second, Mr. Chair.
So take your time.
Okay, so the next amendment, and again, this is an omnibus bill, so the discussion will bounce around as well because of the nature of the many subjects that the bill covers. So with the third amendment, this is adding Delegate Wells's HB 1274 into the bill. Specifically, what that bill does is for failure to pay rent actions, it requires a landlord filing a complaint and the failure to pay rent action to include evidence that the complaint or that the landlord has provided the tenant with the prior notice of the intent to file. So that is the bill as drafted, and then there was 2 amendments made as well, which are where one was based on judiciary's feedback, and then there are 2 others from Legal Aid and Public Justice Center. The judiciary's amendment was about regarding the proof was to change. It originally said evidence, but that was changed to be proof that the landlord has provided the notice required, and that was based on the specific terminology that's used by the courts.
What page
And
are we
then-
on, please? I'm sorry.
No, you're this and Vice Chair Boyce, this amendment, I'm not sure that everyone has a copy of, but it's one that it's regarding page 15 of the bill, particularly the section 8401, which is the failure to pay rent actions.
Thank you.
So that's pretty much the amendment. It adds some clarifying language that for the notice for electronic notice, they have to provide the landlord with proof of the transmission of the notice. And then there's a third part, which is the landlord cannot condition the acceptance of a lease on the tenant's election to receive notice under this subsection by electronic delivery because of issues that people have with, proving that they've received electronic notice or some, difficulty like that.
And here what we're just trying to make sure that we do is provide proof that the tenant is in fact receiving notice. That's what we're trying to outline here, just to make sure everyone understands that the notice has been provided and proof that it has been sent out. Delegate Naraki?
Thank you, Mr. Chair. What is just so I understand, because I'm still a little unclear, like what is the definition of proof or the definition of evidence here? Who's going to make that determination? Is that a clerk at the court? Is that a judge? Like how does the landlord, in this case, demonstrate proof? Because we also have sort of conflicting things going on here where you can use electronic methods in some situations, but not in other situations. So I'm just trying to understand here what we're doing here.
Sure. That and if there is a discussion or a dispute, obviously that all of that gets ironed out inside of the court system in terms of whether proof is substantial enough or not. Ben, you want to expand? And then we could also, yeah, Ben, you want to expand?
Yeah, I think proof could take on a lot of different forms. Just depends on the eyes of the courts. What would they, it's not like a specific set of criteria. It's just like a more general term that they would use.
And this, again, this would be in front of the circuit court so that they could make the decision whether substantial enough proof was in fact provided, which is, you know, the normal course of events in these particular cases anyway. You go to court, and then the judges make the decisions one way or the other based upon the evidence that is provided.
So in this case, just as an example, Mr. Chair, proof could be a copy of the certified mail here in this. I'm just trying to understand because we got a couple different things going on here. So like a copy of
right. Either copy of the certified the certificate or a copy of the mailing from the U.S. Postal Service, or in case of electronic, something that indicates that electronic email was in fact sent. Some type of proof where you stand there in front of the judge and the judge says, did you, Mr. or Mrs. Landlord, provide this? And you present the judge with the documentation. That's what we're trying to do here, just to make sure that there's an opportunity for the landlord to present themselves, and for the tenant to understand that the landlord does in fact have to present the proof.
Okay. Thank you, Mr. Chair.
Certainly. Any additional discussion on this particular amendment? If not, I'd like to take a motion on amendment number 3.
Move the amendment.
Is there a second? Second on the amendment? I need a second. Thank you very much. The amendment has been moved and seconded. Any additional discussion? Seeing none, all in favor of amendment number 3, signify by saying aye.
Aye.
Any opposition? Very good. That amendment will receive a favorable report from the subcommittee as well. Then please go to the next amendment.
Okay, thank you, Mr. Chair. I'll pull up my screen here. And this is one that I've been working more closely with Brad on as well. So it might be, maybe Brad will have some thoughts too, but I'll definitely get started here.
Thank you.
Okay, so the next amendment is doing a few things. We got a chance to go over this a bit last week as well. The first part of the amendment, though, is striking the housing assistance programs and the voucher program from the bill. Brad mentioned last week that this was being done because of just like general issues with these types of vouchers with public housing agencies and having priorities. So that it was accordingly struck. And Brad, I don't know if there's anything else to add for that.
Brad, you wanted to speak upon this if you don't mind?
Absolutely. Yeah. Thank you, Mr. Chair and Ben. Ben about encapsulated it. The statewide rental assistance voucher program doesn't receive its first round of funding until fiscal year 25 in July. And while they're balancing that and balancing federal and state law, the providers expressed some concern. So hearing those, we're just moving to remove this section.
Great.
Okay, and then we'll go to the next part of the amendment. This is for the Office of Tenants' Rights, and it's adding a few items as well to what the duties of the Office of Tenants' Rights are, which includes referring covered individuals in the real property article to the access to counsel and evictions program. It also requires that the Office of Tenants' Rights collaborate with local and county governments. And then there's additional language being added about adopting regulations and receiving notices under section 8119, which was also amended and relates to tenants' exclusive negotiation period and the right of first refusal. So that brings us to section 8119. And again, this is creates new pathways on home ownership by providing a right of first offer and a right of first refusal. This was based on existing bill language, but there was a bunch of modifications made and alterations. So you can see that that section was struck out and then a new section was added in. There's some different terminology, like in other terminology like that. But going into the substance of the bill, one thing it does is it cuts the applicability for it down to four units to those with 3 or fewer. So a residential rental property with 4 or more individual dwelling units would not be subject to this section. It also, things like transfers of title from the state or local government. But moving into the actual section here, there's 2 things going on. The first one is the offer of is a right of first offer. So under the bill, before a residential property can be offered for sale to the public or a third party, including through a listing for sale, like with a real estate broker, the owner and any tenant or a group of tenants may enter into or shall enter into the tenant's exclusive negotiation period for the purchase of the property. And so what that does is they're all given a notice, and the notice has material terms about the property, that it's a solicitation for an offer, that information regarding the deadlines for the tenant to submit an offer to purchase. This is the 30-day period for the right of first offer. So they see that notice, they have 30 days to the tenant can deliver to the owner a written offer to purchase the property. And then within 5 days of that receipt of the offer, the owner, if it has the same or more favorable terms, shall accept the offer and notify the Office of Tenants' Rights, which we got to look at in the previous section. And then the language continues and the process continues if it contains terms that deviate from the notice that the owner provided to the tenants. And then we have a little provision here about if it's more than one tenant or a group of tenants delivering a timely offer to purchase the property, the owner can select the more favorable offer without liability to any other tenant. So moving through the rest of the language here for the right of first offer, if the offer deviated from the terms that were provided in the notice, within 5 days, the tenant can accept the counteroffer from the owner or reject the counteroffer. And then if the tenant fails to respond to the counteroffer within 5 days, it's deemed to be rejected, and the owner shall notify the Office of Tenants' Rights to ensure people are complying with the bill and complying with this program. Next, let's see. A tenant's right of first refusal. So if a tenant's right of first refusal in 5 year is terminated, then the owner must notify the Office of Tenants' Right if the tenant does not deliver an offer to purchase or accept a counteroffer. And what this is about, which is a segue into the next section of the bill here below, is we just went through the right of first offer, okay? With like you're getting the chance to have a first offer with the owner who's selling the property. But if you don't exercise any of those rights under the right of first offer, you're not entitled to the exclusive right of first refusal. And Brad, I don't know if there's anything else to add on that first part.
Yeah, Brad, could you first off, Brad, if you could expand upon the Office of Tenant Rights, and then expand upon the right of first offer as discussed by Ben. And then I saw that Delegate Rocky had a question, which might be answered in your discussion, Mr. Fallon.
Yes, sir, Mr. Chair. So then, and again, thanks. So the office tenants' rights section here obviously creates that office. The relevant amendment here requires the office tenants' rights to host some sort of what it'll look like is a portal, so that if you are a landlord and you need to provide a notice to the individual to make sure there is a written record of when those are sent out to protect both parties in the situation, we will set up a process through the office tenants' rights. What that'll likely look like is that they complete a portal. That portal keeps something in the records for the office and then sends a trackable letter out to the tenant. Once that tenant were to receive the letter of a offer to sell the property at a certain rate, the clock would start ticking. They would have 30 days by which they would have to respond. If they respond within that 30 days, there is a period for the landlord to either accept the kind of counteroffer or the offer that comes back in, or provide a counteroffer to the tenant. The tenant at that point can either deny the counteroffer, at which the right of first offer has been refused and waived, and they have neither a right of first offer or a right of first refusal, or they could accept the counteroffer, in which case they would move towards sale. So it's really kind of an elegant solution to get out ahead of this so that it doesn't delay any timelines. And again, this was a compromise that we worked out with the Realtors Association and the Land Title Association, who are now supporting the bill, and that has removed all opposition from this section.
And that was going to be my next discussion item with you, is to make sure that what we have prepared here is in fact in response to the opposition, and we've taken care. I'm glad you said that, because I was just getting ready to get to that. You must be reading my mind. Delegate Naraki, do you still have a question?
I do, Mr. Chair.
Yes, sir. Great. You have the floor.
Thank you, sir. So we passed a bill last year in this committee. Well, maybe it actually might have been in land use. I'm sorry. I think it was out of land use. It was Delegate Stewart's bill with respect to mobile home communities and the right of mobile home owners to purchase the mobile home park, essentially, if it comes up for sale. Obviously, I know that we're talking about something slightly different, but those timeframes were different. All that, does that impact that in any way here? With that, would that have any impact on that? Because I wouldn't want to see anything impact that. A lot of issues in my district in mobile home communities. That's why I'm asking that question there.
No, it might even be in a totally different article.
Okay.
Yeah. So the mobile home park scenario is different. And I do remember that bill as well. That bill had been in for several years prior to coming out last year as well.
Okay.
Yeah.
Thank you, Mr. Chair. I just want a point of clarification. Thank you.
Sure. Any additional discussion on this particular amendment? Hearing none, do I have a motion to approve this amendment, please?
Move favorable.
Is there a second? I heard a second. All in favor of this amendment signify by saying aye.
Aye.
Any opposition? Fantastic. This will receive a favorable also in terms of this amendment. Ben, I think that's it for us. Is that correct?
Yeah, the bill's been moved as amended. That's the only bit on one we have on the agenda. So
Thank you very much. I need a motion. I need a motion favorable on the bill as amended, please.
Move favorable.
Second.
Second, and I see a question from Delegate Boyce.
Thank you. I'm having a hard time following, and it may be me, but I have 3 copies of this bill that were sent, and I'm trying to figure out what is the official copy. Mine is the bill, the amendment we spoke about first, which was Delegate Naraki's amendment that Ben added, but is not necessarily added. So I do have 3 different copies of this bill, and they have different dates at the top, and I'm trying to follow through.
I got it. We'll get something in this finality to you.
Well, I don't need a final. I felt like I was following 3 different bills. Copies of the bill. Is the bill that is dated 3/4 or 3/11 at 2:35 the most current bill?
If I may, Mr. Chair.
Please, Ben, help me.
Okay, yeah, no, it's fine. The dates there at the top, those are the date for the reprint, the date that the reprint was created for the specific amendment.
Okay,
The amendments that we went through are the ones that we've been, that, you know, those, so it's not like there's other amendments or you've missed anything for what it's worth. We covered the amendments that, you know, were brought up, and we went through them. I certainly appreciate that it's better to have a single global document. It was just, I
it's
think,
me. I just get confused.
no, it just takes like,
Oh, so I see what you're saying. The amendments were printed in 3 different copies. Is that
yeah,
what
they
you're
start,
saying?
yeah, as opposed
Okay.
to like,
I get it now. I'm sorry. Okay, I just have
That's
to
fine.
go through each 3. Okay, thanks so much. I'm sorry. Thank you.
That's okay. I see Delegate Naraki. Hang on a sec. I just want to make sure I provide a point of order in terms of where we are, so everyone understands where we are. We have a motion and a favorable on the bill as amended, and we are now in the discussion period on the bill as amended. I just wanted to give a point of order so everyone understood where we were. Delegate Naraki?
Thank you, Mr. Chair. So we're on the bill now, right? I just want to make sure we're in the right spot for me to talk about the bill, not amendments.
That is correct. We are
Okay.
on the bill as amended. Yes, sir.
Okay, thank you, Mr. Chair. Just want to make sure I was in the right spot.
Yes, sir.
Are we still in the same posture with respect to the recoverability of fees? Were there any changes with that? And where are the folks from the various MMHA and AOBA and things like that with respect to where that is? Has there been any negotiations with those organizations to try to reach some compromise?
The answer to the question is the bill is still in the same position in terms of recovering of the fees, and that is no. From the landlord. That is still the same position we're in now.
Now, Mr. Chair, as I understand it, would we, as I understand, we'd be the only state in the country that would be in that posture then, where there would be no recoverability of fees? I believe every state has some recoverability. That's my understanding, at least.
I'm not certain of that point. Mr. Fallon, if you are still available to discuss the uniqueness of Maryland, I certainly would appreciate it.
Yes, sir. Thank you, Mr. Chair. And Delegate Naraki, as we've discussed, that is accurate. We also have an eviction filing rate that is 7 times the national average, is down from 14 times. There's a plethora of reasons that the structure is quite a bit different. And so this is sort of a Maryland-based solution, a unique solution.
And I appreciate that, Mr. Fallon. But as I understand it, other states have, the right of redemption. They also allow for future rents and things like that in the process, which I believe that also makes us very different, and why you may see more filings in Maryland than you do in some other states.
We do a future rent in Maryland.
I realize it's in statute, but I don't believe that it's really in practice in the courts. I don't know that the courts really often fined for future rents.
I have heard that from the landlords as well. When we look back at records, I have not found that to consistently be the case. But Delegate Naraki, certainly, if you have something to point to, I would be very happy to bring that into discussion.
Okay. Thank you, Mr. Fallon.
Thank you. Delegate Lehman, you have the floor.
Thank you, Mr. Chair. And I absolutely do not want to see any of the language on recoverability change. Landlords had it great for how many years was that filing fee? $15, and there was no issue around recoverability because they were filing for eviction left and right. So it's been so one-sided, it's not even funny. I do have a question though, which is about whether this bill now applies to one single units or units up to buildings up to 3 units. Where did that change? When I saw groups of tenants, I was confused because I thought it was only a single unit that it would apply to. So where did we end up?
It's Ben, correct me if I'm wrong, 3 units.
That's right, Mr. Chair. That was one of the amendments for the right of first offer and first.
Okay, we went through a lot, respectfully, we went through a lot of information, and there's a heck of a lot of struck language in here. It's hard to even follow the up and down scrolling on the screen. So now it is applicable to buildings up to 3 units. Is that correct?
That is correct.
Okay, and is that a change the administration had sought?
Yes, Mr. Fallon, you want to speak to that? In some cases,
And I'm fine with that. I just didn't know where it came from, Mr. Chairman.
and in some cases, when you start talking about 4 units or more, it falls into a commercial definition. Mr. Fallon?
Yes, sir, that's correct. Delegate Lehman, we do support that. That was worked out because there is a jurisdiction in Maryland that defines 4 or more when creating their multifamily right of redemption, and we didn't want to have overlapping processes. So this would be your duplexes and your triplexes.
Okay. Okay, thank you. Thank you for the explanation. Thank you, Mr. Chair.
Yeah, we just didn't want to impede upon the definition of commercial with other jurisdictions. We have in front of us now the bill as amended. We have a motion and a second. We are still in the discussion period on HB 693 as amended. Any additional discussion on HB 693 as amended? Delegate Boyce.
I just want to clarify, and I know we had this conversation before about not being able to recover the fees because in most cases, rent is redeemed, and thereby because landlords hopefully will file less so quickly, especially for those people who end up redeeming the property, that with all due respect, if a landlord would continue the practice of continuing to just file on a tenant that ends up paying anyway, then it's unfortunately a cost that they would eat.
That is correct.
Okay.
That was some of the discussion that we heard.
Yeah.
And that is what's happening here in this particular piece of legislation.
And just so to clarify, I know the people who are worried about the fees, the right to redeem is not necessarily trying to take money out of the landlord's pocket, but to get landlords not to be so quick to file when in most cases, tenants who are whatever for a reason chronically late, rent's due on the 10th, they pay on the 25th, it would keep them from filing unless it was absolutely necessary.
That was some of the discussion that we did here, yes.
Okay. Okay, I just wanted to clarify, thanks.
Okay. Any additional discussion on HB 693 as amended? Seeing none. All in favor of HB 693 as amended signify by saying aye.
Aye.
And the opposition, please.
No.
Oh,
That's Baker and Naraki. Thank you all. HB 693 will receive a favorable recommendation as amended from the subcommittee. And ladies and gentlemen, I do understand that we had other bills on the docket for this afternoon. However, the amendments have not yet come forward. We're still waiting on the amendments. And I did not want to have discussions without amendments being available to us to look at or discuss. So we will have the other bills that are on this docket at a later point, very, very soon. So at this point, ladies and gentlemen, Housing and Real Property Subcommittee is adjourned. Thank you.